It's a real honor for me to be here during Victim Rights Week and to discuss a topic that I've worked on my entire career, hate crimes, with all of you. But before I turn to that topic, I just wanted to reflect with you briefly on an experience I got to have over the weekend. I was in Oklahoma City Friday, Saturday, and Sunday, both for a Homeland Security and the law conference with other U.S. attorneys who have an interest in that area of law, and also to attend the memorial ceremony for the 20th anniversary of the bombing of the Alfred Murrah Federal Building in Oklahoma City, in which 168 people, most of them employees of the federal government, 19 of them children under the age of 6, were killed in what is regarded as the largest domestic terrorism incident in our country's history. There was a very moving ceremony there on Sunday morning to honor the victims of that bombing and the survivors. There were more than 700 people who were injured in addition to those who were killed. Has anyone here ever been to Oklahoma City? Yeah, and have you been to where the memorial is? Yeah. I mean, and it's the federal building was very much downtown, in a much more compact downtown than we have here in Boise. The federal building in Boise sits off by the VA hospital, not really near a lot of other buildings. But there were another number of other buildings that were damaged, including 4 state workers in a building that was across the parking lot from where the blast occurred. And one of the things that was significant about that incident was it really led to a reform at the federal level of victims' rights, as there are probably not all that many of you here who really were familiar with this incident when it occurred and the trial that followed. But the federal trial was moved from Oklahoma City to Denver in order to get a jury that would be not be as biased against Timothy McVeigh as others might have been. And so that was a real, as you might imagine, a real inconvenience to those victims and victim family members and survivors who wanted to watch the proceedings. And in federal court, the proceedings are typically not televised, but they made some arrangements to have the proceedings covered by closed-circuit television so that individuals who were still in Oklahoma City could watch the proceedings. In addition, the Justice Department was able to carve out some funds and flew a group of 10 victims each week up to watch the proceedings. Following the trial of Timothy McVeigh, there were changes made to some of the federal victim rights laws and sort of have us where we are today, which give many more rights to victims, primarily to appear in court and attend proceedings, even though they may later speak at the sentencing. So I know that's off topic for what you were promised here, but I thought, it was really such a meaningful event in this nation's history, and really in the work that in the federal government we do with victims' rights. I wanted to at least mention it. So now I'm going to talk about hate crimes, and I'm going to talk about hate crimes primarily from the federal perspective, and also the impact on victims that we see in the federal government. So I'm going to start with some statistics. So these statistics are from the FBI's most recent hate crime statistics compilation. This is the most recent one. The figures were released in January of this year, but because of all the work they have to do to sort of compile and collate, it takes them about a year to put the report out, so we're always basically a year behind. So the total number of reported hate crimes incidents, 5,922, which was down a bit from the past years. Typically the figures run between 6,000 and 10,000, and these are not federal hate crimes. These are incidents that are reported by state, county, local law enforcement. As you can see, for those reported hate crimes, the vast plurality of those, almost 50%, are based on race. The next highest number or percentage are attacks based on sexual orientation. And I'm not going to read the whole slide to you. I'm confident you can do that. All right, so then we turn to the total number of victims. A little over 3,500 victims of racially motivated hate crimes, most of them directed at their victims by an anti-black or anti-African American bias. Hate crimes directed at individuals because they are Hispanic or of Hispanic descent are captured in the ethnicity category, not in this category. So you'll see that there were that category is not up there. Then the next largest number, of course, victims targeted due to sexual orientation bias. I thought one thing that's interesting about that and has been consistent over the last few years is that most of the incidents are anti-gay, what are described in this report as anti-gay incidents, meaning they're directed at gay men. A significantly smaller number directed at individuals who are transgender, lesbian, or bisexual. A significant number of anti-religious hate crimes, and far and away the largest percentage of those directed at people who are Jewish. They're based on an anti-Jewish bias. And that is, I think, increasingly true around the world. There have been a lot of media reports over the last few months about the increasing number of anti-Jewish bias crimes occurring throughout the world. The next highest number or next highest percentage is significantly lower, 13.7%, that are anti-Islamic or anti-Muslim hate crimes. One, I think, important footnote to this, and probably if you were to speak to civil rights groups, advocacy groups, and many commentators, these numbers are believed to be significantly underreported. Does anyone here know how the FBI gets its hate crime statistics, or want to venture a guess? Because the FBI is the lead federal law enforcement agency. At the federal level, they have the primary and almost exclusive jurisdiction to investigate hate crimes.
Is it all UCR data?
It's all UCR data, Uniform Crime Coordinator. So it's self-report by local and state, county law enforcement agencies. So it's what they're putting in to the system. And the FBI does do a fair amount of outreach and liaison work with its local partners to encourage them to report these, but as you might imagine, some jurisdictions are going to be hesitant to report hate crimes. Sometimes there may not have been enough investigation done to determine whether the crime was a hate crime, an assault that was not motivated by hate, those sorts of things. So there is a significant belief that these figures are underreported. So this guy's name is Michael Bullard, and this is a picture when he was arrested on our federal indictment, and just sort of to underscore that we don't catch like the brightest ones all the time, and that sometimes you can't make this stuff up. I mean, one of the things you have to prove, and I'll go over this in a minute in more detail, in a federal hate crime case is that the defendant acted because of the protected status, in this case race or perceived race, of the victim. And so this guy, what he had on his jacket at the trial, if you can see there, I don't know if you all can see around the podium there, this little lapel pin, so swastika, and then the one on the other side, the SS lightning bolts. So we actually introduced this arrest picture at the trial as evidence of his racial motivation. So cross burnings are very commonly prosecuted in U.S. Attorney's offices and by the department throughout the country. We're going to talk a little bit about what it takes for a cross burning to be a crime, as opposed to a message that maybe some members of a white supremacist group want to just celebrate what they like to do. Threats, they're under a couple of the statutes that we have, threats that are conveyed by phone, which we would do in the old days, mail, which also was done in the old days, email, and I probably need to expand this slide to talk about the things that Mr. Groves was just talking about, by texting, by posting it, depending on how it's posted, to a Facebook page, Instagram, Snapchat. All right, victims. Who can be a victim of a hate crime? Anyone can be a victim of a hate crime. The protected statuses under these statutes are set out neutrally. It doesn't say that it's against the law to assault somebody because they're African American or Asian or Native American. It makes it against the law to assault somebody based on their race, and everybody in here has a race, nationality, sexual orientation, all of those protected statuses. The 2009 Hate Crimes Act, which I'm going to talk about in some detail, provides the broadest protections in terms of protected statuses. And then the Fair Housing Act, which was passed in 1968 and deals primarily with protections when you're looking for housing, also has a criminal component to it. And then there are a couple of other statutes. I've listed them by number at the bottom, 241 and 245. Statutes have numbers. Are most of you sort of familiar, at least generally, with criminal codes and how they're written? They have a volume number and then a statute number. So Title 18 is the code book in the federal statutory code for crimes, and then the number after that is just how they're in there. And in case it ever comes up and you're curious, they are listed alphabetically. So civil rights crimes are pretty low down, and they fall under the broader civil rights rubric. So they're in the 200s. Fraud crimes, they're a little higher up. You know, F comes after C. They're the thousands. The sex crimes are toward the end, and then the terrorism crimes are even further back. So if it ever comes up in trivia, that's how it works. So we have non-housing hate crimes, and in the federal system, housing hate crimes. So the non-housing hate crimes, there are two of those. There you got their numbers, 245 and 249. 249 is the newest statute. I'm going to spend the most time on that. And then the Fair Housing Act, which is, as you can see, in a different part of the U.S. Code because it deals mostly with housing and civil rights stuff. And then we have a special civil rights conspiracy statute. The civil rights conspiracy statute is the oldest of the federal civil rights statutes. It was passed during Reconstruction in the 1870s, and it was passed really initially to deal with crimes and activities going on in the South by members of the Klan or other hate groups. And it actually talks about when individuals go on the highways in disguise, conspiring with one another. And so we don't necessarily have too many people these days going on the highways in disguise. It's not necessary, but that's the origins of that statute. So the non-housing hate crimes, 18 U.S.C. 245. It's also referred to as the Federally Protected Activities Statute. It was passed in the late 1960s, which is, of course, a time when there are a lot of civil rights statutes passed at the federal level. And it requires, when we do criminal cases, we have to prove certain things called elements. And so we have to prove that there was a use of force or the threatened use of force. The person has to act willfully. That means they have to intend to do something that they know is against the law. They don't have to know what law they're breaking, but they have to do something that they know is against the law. So, for example, if you beat somebody up for no good reason, I think over the age of about 3 or 2, depending on how good your parents were, you have a pretty good sense that you're acting against the law. Probably if you light somebody's house on fire, you're there as well. You have to prove that the individual is acting because of race, color, national origin, or religion. So this is probably one of the narrowest statutes in terms of protected statuses. This is it right here. 18 U.S.C. 245 doesn't include protections based on gender, disability, or sexual orientation or gender identity. Passed in the 1960s, so those were not really on the radar screen. And then we also have to prove that the defendant acted because the victim was enjoying a specifically listed federal right. So when this statute was passed in the late 1960s, it was a time of great unrest in the country. There were riots going on in certain urban inner cities, and certain members of Congress were concerned that if this statute were too broadly interpreted, that law enforcement officers who were trying to squelch those riots, and the perception was that a number of the rioters, or the majority of the rioters, were people of minority races, that they could be in violation of this statute. So this requirement that the defendant act because the victim is enjoying a specifically listed federal right was added to the statute. And then it's a misdemeanor if it's a threat, but it's a felony if you do any of these things. And the difference between a misdemeanor and a felony is misdemeanors punishable by a year or less, felonies punishable by a year or more in jail. So these are the specifically listed federal rights: right to attend a public school, right to use a state facility or program, and that would include things like what's close by here. Probably this building, but also a Taco Bell Arena would be considered a state facility or program. The football stadium would be considered a state facility or employment. Right to employment, right to serve in court. That part of it's almost never used. The courts are places where there's really very little threats of violence or violence directed against people these days. Right to use a facility of interstate transportation. and right to use a place of public accommodation, and that's really the most common federally protected right. So a place of public accommodation can be basically any place that invites the public in to participate in what's going on there. So theaters, restaurants, anything that's really trying to draw people in. And we go back to Mr. Bullard, the guy with the lapel pins. That was a public accommodation case, and I'll describe that in a little bit of detail. So the second and the more significant non-housing hate crime is the statute, is the Shepard-Byrd Act of 2009. This was legislation that was designed to get rid of that because of element. It had become one that was sort of a challenge to prove at times, and these two examples illustrate that. Matthew Shepard was a 21-year-old gay man who was killed in Laramie, Wyoming in 1998. He was basically beaten and left to die on a fence on the outskirts of town. Earlier that same year, in June of 1998, James Byrd Jr., who was a 49-year-old African-American man, was killed in Jasper, Texas. He had been picked up, was looking for a ride, been picked up by 3 white men, 2 of whom were avowed white supremacists and belonged to white supremacist groups. They took him for a ride for a little while, then took him to an area outside of town, got him out of the car, beat him, urinated on him, tied him to the back of their pickup truck with a big heavy chain, and then dragged him down some asphalt streets. They're pretty sure in terms of the forensic evidence that Mr. Byrd was alive most of the time he was being dragged, and then he was killed when he hit his right arm and his head were severed when they hit a culvert. The defendants then took his torso and dumped it in front of a church in Jasper, Texas. The individuals who were responsible for the murder of Mr. Byrd were all prosecuted by the state of Texas. 2 of those individuals received the death penalty. Texas is a big death penalty state. One of those individuals has been executed. The other person was sentenced to life in prison. And in each of these cases, because there wasn't one of those specifically listed federal activities, the federal government couldn't prosecute either of these cases. And so it was left for the states to. And the states do a good job. States prosecute lots of murders. And in a minute I'm going to talk to you a little bit about what I think makes hate crimes different. And so so these two cases had been the impetus for a long period of time to get additional legislation passed, and made it into the name of the act, which is, the long act is the Matthew Shepard, James Byrd Jr. Hate Crimes Prevention Act of 2009, signed by President Obama in October of 2009. So that statute has 3 parts. It has 1 provision for race crimes. You have to cause bodily injury or attempt to do so using a weapon. You have to act willfully, act because of the race or color, or to a certain extent limited national origins or religion. And this one is always a felony. As you can see, there's no threats component to this statute. So threats cannot be prosecuted under this statute. So I'm going to go to the other parts of the statute here in a minute, but wanted to do a brief little constitutional law lesson here that will explain how some of these statutes work. So as you probably all know, because you've had like history and government classes throughout your education, and perhaps here at Boise State, that in order for the United States Congress to pass any legislation, it has to be authorized by some part of the United States Constitution. They can't just act and do whatever they want. You know, we're a federal government of limited authority and limited jurisdiction. And so the two, when we're talking about federal criminal statutes, the 2 most common components that are going to, from the Constitution, that give rise to legislation in this area are the Commerce Clause, Article 1, Section 8. Congress has the authority to regulate commerce among the states. And the 13th Amendment to the Constitution. Does anyone know what the 13th Amendment to the Constitution is? It outlawed slavery, and there's the last part of that says that Congress shall have the authority to make whatever laws are necessary to eradicate the badges and incidents of slavery. So that part of the Constitution has been affirmed and interpreted by the Supreme Court to mean that Congress can legislate in the area of hate crimes and prohibit actions based on a person's race under its 13th Amendment authority.